You've just received a demand letter or been served with a lawsuit. What should be one of the first things you do? When a lawsuit is served, or your company or an individual receives a demand letter for a substantial amount of money to avoid a lawsuit, insurance may not be at the top of the priority list, but it should be one of the first things considered. Not giving timely notice of a claim or a potential claim can, depending on the circumstances, result in money out of pocket that insurance would have otherwise covered. I'm Danielle Gilmore, and I'm the chair of Quinn Emanuel's National Insurance Recovery Group. When should notice be given? As promptly as possible is a best practice to obtain assistance from the insurer as soon as possible, and to avoid any arguments of prejudice by the insurer. Late notice does not always result in a valid denial of insurance coverage, but that depends on the type of policy and the laws in the applicable jurisdiction. What type of policy you have is the most important thing to review when determining the notice requirements. Generally, there are two types of business liability policies: occurrence-based policies and claims-made policies. Occurrence-based policies generally cover claims made for bodily, personal, or advertising injury, or property damage that took place during the policy period. Even if the claim is made decades later, occurrence-based policies are intended to respond to damage or injury that took place during the policy period. For example, property damage that took place many years prior to the claim being made for that damage would be covered under the policies in place when the damage occurred and not when a lawsuit was brought. Insurance policies typically require that notice be given in a timely manner, as soon as practicable, or immediately. There are three main approaches in the United States regarding the effect of so-called late notice provisions. The majority of jurisdictions hold that an insurer may not deny coverage based on late notice unless it can prove that it was prejudiced by the delay. This is known as the notice prejudice rule in many jurisdictions. Other jurisdictions hold that late notice raises a presumption of prejudice to the insurer, but that the presumption is rebuttable if the insured can demonstrate a lack of prejudice. Finally, a minority of jurisdictions interpret notice provisions strictly, holding that insurers may deny coverage based upon failure to comply with the notice provision regardless of prejudice. So what is actual prejudice? The insurer must show that substantial rights regarding the defense of the claim have been irretrievably lost. This showing is highly fact-dependent. If notice is not given and a default judgment is entered, that could be actual prejudice. Settling a case before providing notice may also be actual prejudice. If the passage of time prevents an insurer from conducting an adequate investigation, that would also be prejudice. Who has the burden? This depends on the jurisdiction. For example, California places the burden on the insurer to show actual and substantial prejudice. New Jersey likewise places the burden on the insurer with a showing of appreciable prejudice. Claims-made policies, unlike occurrence-based policies, cover claims that are first made during the policy period. Many claims-made policies are also claims-made and reported policies, which means the claim must be made and reported in the policy period to the insurer. Directors and officers and employment practices liability insurance policies are typically claims-made and reported policies. Notice requirements under these policies are not flexible. In almost all instances, if a claim is first made during the policy period but not noticed to the insurer within the policy period or any applicable extension of coverage period, the insurer will be absolved of providing coverage irrespective of prejudice in the majority of jurisdictions. To be sure you are properly giving notice, read your policy carefully as to what constitutes a claim, because many types of requests or demands may constitute a claim. For example, a demand for monetary or non-monetary relief is a claim under most policies. Lawsuits are claims. Target or Wells letters may be claims. It's important that any request be reviewed against the policy, because if a suit is brought later related to a demand that should have been noticed in an earlier policy period, the insurer is likely to deny coverage. Most claims-made policies allow for a policyholder to provide notice of a potential claim with something called a notice of circumstances. This notice allows the policyholder to tell its insurer about circumstances that may result in a later claim that has not yet materialized. By providing information about the incident or events that lead a policyholder to believe a claim could be made in the future, notice is deemed as having been given in that policy period, even if the claim is made after the policy terminates. Providing such notice is always recommended to avoid any questions about when a claim was first made, and to the extent the policyholder must disclose the potential claim in an application for a later policy, as any such claim may be excluded, leaving the policyholder without coverage. Multiple different policies may provide coverage, depending on the allegations being made. Always provide notice to any potentially applicable policies, including all excess and umbrella policies. Tendering coverage to an insurer requires providing the insurer with a copy of the claim, be it a complaint, subpoena, demand letter, or administrative action. A notice of circumstances typically requires information about any suspected wrongful act that may result in possibly covered claims. Don't forget to tender any counterclaims or cross-claims made against a policyholder. Even though affirmative claims are usually not covered and the policyholder was first to file, counterclaims and cross-claims are defensive and meet the definition of claim in almost all policies and should be tendered immediately for coverage. Of course, we can only cover the basics of giving notice to insurers here. But if we can be of any assistance as to any insurance issues, please contact us in Quinn Emanuel's Los Angeles office.